Hearing the appeal of MUR Shipping BV against RTI Ltd.
My Lords, in this appeal, Mr. Woolnough and I appear for the appellant shipowner, MUR, and our learned friends Ms. Selvaratnam, KC, and Mr. Shirley appear for the respondent charterers, ITI.
Thank you.
Your Lordships will have seen from the papers, this appeal raises a question of law as the application of what is, as at least I will be submitting, a formulaic and unexceptional contractual force majeure clause. Specifically, the question is whether the express reasonable endeavours proviso to the force majeure clause can require the affected party, which is MUR, to agree to vary the terms of the contract and or to accept a non-contractual performance, and that in circumstances where the proviso makes no express provision to that effect. It's silent on the point. Now, depending on whose assessment your Lordships accept, that is either 1, a question or general principle, which is relevant not only to the particular proviso in this case, but also to any other express RE proviso which is silent on the point, and furthermore to all implied RE provisos. Or 2, it's a one-off question which raises no point of broader relevance whatsoever and forced to be decided simply by applying the principles in ICS, Arnold and Britton, Wood and Capita, and so on, to the specific wording of this particular proviso. Now, that question of characterisation doesn't just divide the parties to the appeal. It divided the learned judges in the courts below. Mr. Justice Jacobs and Lord Justice Arnold thought that the question raises a point of general principle. Professor Peel, writing in Lloyd's Maritime and Commercial Law Quarterly, agrees with them. He says that it raises a fundamental point of principle, and I submit that it does. And I also submit that Mr. Justice Jacobs and Lord Justice Arnold were correct that the answer, as a matter of general principle, the answer to the question is no. A reasonable endeavours proviso does not extend to variation and or non-contractual performance unless it does so expressly. Lord Justice Bales thought that the question is a one-off, which turns on the specific wording of the particular proviso, and he thought that the answer turns in particular on the verb to overcome. And Lord Justice Dewey agreed with that. And on this appeal, RTI submits that Lord Justice Mayles and Lord Justice Newey were correct about that, and it submits that they were also correct. The answer to the question of the law in this case is yes, the RE proviso does extend to variation or non-contractual performance. And indeed, the court may have seen from paragraph 2 of RTI's notice of objection that RTI's very first submission is that Lord Justice Mayles and Lord Justice Dewey were right for the reasons which they gave, which really means for the reasons which Lord Justice Mayles gave, because he gave the most substantive judgment.
This emphasis on overcome emerged at the Court of Appeal stage, did it?
Indeed, my Lord, that was a point I was about to make, because RTI, before your Lordships, now adopts the reasoning of Lord Justice Mayles. But as my Lord Hamlin has just pointed out, they're adopting that notwithstanding that Lord Justice Mayles' reasoning and analysis was entirely of his own devising. It did not reflect anything which RTI argued in the Court of Appeal, or before Mr. Justice Jacobs, or indeed in the arbitration. It was not RTI's case at any stage that the answer turned on the verb to overcome, and that was the be-all and end-all. Now,
well, that's history, really. It may be RTI's case now.
It is their case now, Lord. And your Lordship may think it is history, and to some extent, maybe it is. And RTI say in their case, footnote 9, they say, well, the way they argued the case below reflected the way we had framed the question of law on which we got permission to appeal under Section 69 of the Arbitration Act. It's fair enough so far as it goes. The only point I would make is that at no stage in opposing our application for permission to appeal did RTI say that we have mischaracterised the question of law. And I accept, my Lords, as my Lord Hodge implies, it's open to them to say, well, look, Lord Justice Bales, he thought of a point that hadn't occurred to us. He thought of a new way of looking at it, and we gratefully adopt it.
I think as counsel we've all been in that position at some stage.
Quite possible, my Lord. But for all that, I do submit, my Lord, it is a rather striking feature of the case in the Court of Appeal that the majority adopted an analysis which had nowhere formed any part of RTI's case, and at the same time, they rejected all of the arguments on which RTI did rely. And they rejected them out of hand in a single paragraph, paragraph 52 of Lord Justice Males's judgment, where he says, both the broad submission and the narrower submission advanced by RTI must be dismissed. And not much more was said about RTI's case in the Court of Appeal than that. And your Lordships may have noticed from RTI's case, paragraph 54, that although they do say that they adopt Lord Justice Males's reasoning, they also say that they maintain the broad and the narrow case. That's the case that was just two cases that were dismissed in the Court of Appeal. And I do submit more to it, I suggest, than history. There is a very striking disconnection between the outcome in the Court of Appeal and the case that was put by RTI, and I submit that it suggests at least the possibility that something may have gone wrong in the Court of Appeal, and your Lordship will understand that our case is that something did go wrong. Now, what went wrong was this. The Court of Appeal were quite right to reject RTI's case, both the broad and the narrow submission, but they erred in finding an alternative justification for depriving MUR of the protection of the force majeure clause, because the alternative case stated by Lord Justice Males faces exactly the same objections from principle and authority as the case which RTI put. And then one more point, really by way of introduction. Your Lordship sort of seen that at the top of our case, we have a quote from Mr. Justice McCarty and Le Beaupin of Brisbane. At some point in their case, RTI for some reason called it our flag bearer. We didn't intend any particular significance by it, it was just quite a nice quote. And the point that Mr. Justice McCarty made was that force majeure clauses were becoming common about 124 years ago, just in the aftermath of the Great War, presumably as a result of the Great War and its impact on contracts. But notwithstanding that historical fact, so far as MUR's researchers show, and one infers so far as RTI's researchers show, this is the first case in which it has been held, or even argued, that a reasonable endeavours proviso extends to variation and or non-contractual performance. And that's a point which struck Mr. Justice Jacobs at first instance. He said in his judgment, paragraph 86, no authority supported RTI's case. And the principles which could be extracted from Bullman and Fenwick and Vancouver strikes, which I will come to, were against RTI's case. And I do submit that that lack of supporting precedent also raises a question over the majority decision in the Court of Appeal. Now, of course, if there was something in the wording of this particular clause which pointed to the conclusion that this particular clause extended to variation or non-contractual performance, then that would explain the decision very readily. But in my submission, there really is nothing to distinguish this force majeure clause from run-of-the-mill, the general run of force majeure clauses or other force majeure clauses one sees in the case law. And indeed, Lord Justice Males didn't suggest there was anything very striking about it. And in my submission, it doesn't stand out from the herd at all. It's really rather ordinary. Now that takes me on to the contract, which contains the force majeure clause. Before I do that, I should mention to your Lordships that RTI have a transcriber. You can't see them, but I'm told that they're there, and I'm also told that they would like a break at about 12 o'clock, if that is agreeable for your Lordships, for about 10 minutes.
They have one it's highly unusual for this court to break for that reason.
My Lord,
I'm not aware of that the court has been given any notice of this request.
My Lord, because one of the reasons we didn't want a transcriber was I didn't want to give up time. So I'm in your Lordship's hand about that.
My Lords, may I rise? I understand that those instructing me have in fact liaised with the registry, and they are fully aware that the transcribers are going to be transcribing this hearing. The transcribers, who are EPIC, have requested a 10-minute break every hour and a half, and the parties have agreed that they will divide those breaks equally between themselves over the period allotted for the speeches. We're in the court's hands as to whether, in fact, they're going to accommodate the breaks, but the transcribers are online and will be transcribing the hearing.
I mean, has this request for a break been intimated to this court's registry?
Yes, it has.
When?
I'll have to take instructions. Yes, they're just checking the emails, but certainly it accords with...
Yes, well, I think this is a case where I think counsel has ample time in a day and a half to present their submissions, and if it is coming out of your allocated time, the court will accommodate it.
I'm grateful.
But for some reason, I wasn't given advance notice of this request.
I'm sorry about that.
No, I mean, it may be something that internal to this court, so there's no need to apologise. We will rise for 10 minutes at 12 o'clock.
Thank you so much.
Now, my Lords, the question of law arises under a force majeure clause in a contract of affreightment dated the 10th of June 2016, and it's probably sensible to look at the contract at least briefly. It is in the core volume, page 263. And what I hope your Lordships will have at page 263 is the recap. And it's dated at the top 10th of June 2016, and your Lordships will see from the shipping period, this is a 2-year contract from July 2016 to June 2018. If you drop down towards the bottom, the load ports and the discharge ports are Conakry, Guinea, and Dnipropetrovsk, Ukraine, respectively. Just above the ports is a clause headed cargo size, in which your Lordships see that the cargo, the commodity, is bauxite in bulk. And above that is the volume, which is 280,000 metric tonnes per month, 15% more or less in charterer's option. And then below that, the individual cargo sizes are 30 to 40,000 metric tonnes, 10% more or less in owner's option. Now, depending upon exactly how the volume option and the cargo size option are exercised, it works out at about 6 to 8 shipments every month. And the load terms towards the bottom, your Lordships will see that the loading rate is 12,000 metric tonnes per weather working day, Sundays and holidays included. And at that loading rate, loading will have to be performed on most days of the month in order to hit the monthly target. And the tribunal made a finding of fact that the loading berth at Conakry would have to be more or less continually occupied to meet the monthly cargo quantities. Then over the page at 264 of the volume, towards the top, the freight is $12 per metric tonne, and then other terms are as per an executed charter party dated 21st of June 2013, with amendments. I'll come back to the amendments in a moment, but the executed charter party is over at 265. And I think on 265 one only wants to look at box 14, roughly in the middle. 90% of the freight is to be paid within 5 banking days after releasing bills of lading. Now, just 2 points to note about the freight, taking box 14 and the reference to freight in the recap together. The first is that the freight is denominated in US dollars. And the tribunal held that RTI was obliged to pay and MUR was entitled to be paid in US dollars. In front of Jacobs J, RTI pursued various arguments that it was in fact legally entitled to pay in euros, Mr. Justice Jacobs rejected all of those arguments, and there's no appeal against that. So it's a dollar contract. And the second point that your lordships will note from box 14 is that the freight for each individual shipment is payable after release of bills of lading, and so after the loading part of the cargo operation has already been completed. But if one is having 6 to 8 shipments per month over 2 years, then as a matter of practice, one will quickly establish a fairly continuous flow of freight, paralleling the fairly continuous flow of cargo operations at the load port. And in terms of the parties' objective intention, I would submit that the parties would have intended that the flow of payments would fund the flow of cargo operations.
Just forgive me, but where do we go to see the dollar requirement?
My lords, if you go to 264, very near the top it says freight, including BAF, that's a bunker adjustment factor. It's dollars, denomination, and then just for completeness, if your lordship looks at box 14 again, you'll see there's a cross-reference there to Rider Clause 20, and the completed Rider Clause 20 is at page 276. And the freight is again there denominated in dollars, and again it's the same $12. Now, if your lordships would go, please, to the bottom of page 274, the core volume. There's a clause there, clause 36, and that's the force majeure clause under which the question of law arises. Now, we have discussed the structure of it in some detail in our case at paragraphs 17 to 25, and I don't propose to go through all of those points orally.
I think you say this is a Costco clause, do you?
It appears to be a Costco clause, to judge from the top right-hand corner, my lord, yes.
But there's no finding about that. It's just
There's no finding about that.
you get that from the specimen charter party. Or
No, why it's a Costco clause, I don't know, because Costco aren't involved, but your lordship is quite right, as far as one can tell from the document. All of the rider clauses to the charter party, beginning at page 268, are Costco products, it were, but there's no finding about that. Your lordship is right. Now, without going through all the points you've made in the case, I did just want to highlight a couple of features to come back to the point I made in opening, that our submission is that this is a fairly unremarkable clause in terms of its structure and its content. So one sees, for example, at clause 36.1, there's no liability for damage, delay or failure in performance caused by a force majeure event. And while there is a force majeure event, performance will be suspended. That's orthodox. Relieving parties from liability or from performance is what force majeure clauses are all about. It's the very nature of the beast.
and it's mutual.
It is indeed mutual. Both either party may be an affected party, and whoever becomes an affected party is entitled to invoke force majeure. It's not one-sided. My Lord, obviously the suspension of performance under clause 36.1 is by contrast with the common law doctrine of frustration, where the contract is automatically discharged. Parties enter into force majeure clauses precisely in order to modify the common law position. Perhaps the only point to note about that is that RTI's case at paragraph 10 says that clause 36 caters for, quote, frustration-like situations, unquote. Well, we see from clause 36.1 on the suspension of performance that it's less dramatic in effect than frustration. And if it matters, and it may well be that it doesn't matter, but I would submit that it will also apply in situations which fall short of frustration. For example, a delay, which is not sufficiently long that it would frustrate the contract at common law. The suggestion on RTI's side appears to be that it's simply the common law frustration, but with the qualification that there is suspension instead of termination. But if it was simply the common law frustration with a modification, its effect would be very narrow. There's really nothing in the wording in my submission to suggest that it is intended to be very narrow. Clause...
I mean, your submission is that the common law doctrine of frustration is, in comparison to many force majeure clauses, including this one, a narrow and quite extreme doctrine, because one needs radically different performance. For example, you need that, but then its effect is automatic termination.
Yes, my lord. And it's very often been said in the case that it operates within a narrow compass.
Yeah.
And the test is very severe, and no doubt one reason why the test sets a very high threshold is, as your lordship says, if the test is satisfied, then that's it. The contract is automatically discharged for all time. And plainly, this clause does not do that. It qualifies by allowing you to suspend the contract and come back to life.
It doesn't apply, as some clauses do, to hindering performance.
Yes. It applies to prevention or delay. It doesn't have hindering. Obviously, the words, there has to be some defined effect on performance that the force majeure event has, and a number of words are used: delay, prevention, hindering. This clause uses delay and prevent. They're both fairly common. There's nothing unusual in my submission about saying delay or prevention. Indeed, the discussion of chitty says that those are among the most common words one sees in FM clauses, so that doesn't particularly stand out. 36.2, I just ask your lordships to note this point. Clause 36.2 illustrates what I submitted is a fairly self-evident but nonetheless valid point, that if the parties intended that anything to be done under the contract should be changed in response to an FM event, then they could have said so. They can say so in terms, and they do say it in 36.2. I'll come back to that when I come to the points of principle on which I rely. Clause 36.3 under A, B and C sets out various criteria.
Sorry, just before you leave that,
My lord, yes.
I'm not sure I quite follow your point as to, you're saying they could have expressly dealt with it. Do you mean in an analogous way to 36.2?
Yes, my lord, they did. In 36.2, they have said in terms that something may have to change in response to FM.
Yes. So your point is, if they wanted anything as radical as alternative contractual performance, they could have said so in 36.2.
That's the point. As I say, it's a very short point.
It is a short point.
But nonetheless, in my submission, valid. You know, they were alive to the possibility. It's not just that they could have thought of it, but they did think of the possibility of change under 36.2, and they didn't later on.
But how would you express it?
My lord? If
you were applying it to change the contract, I mean, you wouldn't say as may be appropriate, would you?
You would say that the test that's put in D is reasonable, and you could simply say reasonable, including, if it is reasonable, variation of the contract or alteration in performance.
In general terms?
No doubt one could put it more elegantly than I have just done. I don't doubt for a moment one could. But it would not, I would submit, be an unfeasibly difficult challenge which the parties would be incapable of rising to.
Are you aware of any example of such a clause?
No. No more than I'm aware of any case in which it's been held that it's the effect.
But you're saying
it's just not something that would readily occur to parties to do. Sorry, my lord.
36.2 is not applicable here because we're not talking about the end of the force majeure event. Otherwise, it might be thought to embrace the sort of idea being put by the other side.
Yes, it might, but the point is that it's expressly stated. And your lordship is right, and it's a point that RTI make. They say, well, you can't draw any conclusions from 36.2 because it's looking at a separate point in time, and that's right, that's fair enough. No one is suggesting that 36.2 is applicable here because it's looking at a later point, but the timing point doesn't alter the principle. A, if the parties wanted to say it, they could have said it. And B, they did expressly say it in one part of this clause.
Would 36.2 be limited to the shipment schedule?
On the face it appears to be. There is provision elsewhere in the contract for the formation of monthly shipment schedules. I haven't taken your lordships to it, it's quite complicated, but notice has to be given, and I believe that has to be narrowed. And a schedule has to be worked out every month, and this is specifically saying that if there is a force majeure suspension, I suppose the thinking is there'll be a period in time during which no shipments take place, and then you have to find a way of catching up.
Yeah.
And so you have to alter the schedule. So yes, it is specific to the shipment schedule. It's specific to a time after the force majeure event has ended. So yes, I don't suggest that it's bang on point. If it was bang on point, it'd probably be against me.
Yes, your point is it's a clause coping with a force majeure event.
Yes.
And it isn't as radical as the one that you're challenging, the interpretation you're challenging.
It's right. And it just shows that the parties could have dealt with it expressly if they wanted, and within the confines of this contract, they were alive to the possibility of change. But nevertheless, they didn't incorporate anything like that into the reasonable endeavours provided. 36.3 in subparas A, B and C, my lords, it sets out various criteria which an event or a state of affairs must meet before it will qualify for force majeure.
So these are definitional?
It's a definition of what the event or state of affairs is, my lord, and it's in 3 parts, and it's all, I submit, relatively unremarkable. Outside the immediate control of the party giving the notice, that's relatively standard, but events have to be outside the control of the party. B states the causal impact. My Lord Hammond has already highlighted its prevention or delay. Those are not particularly unusual causal requirements in a force majeure clause. And then we get in C what some of the textbooks call the laundry list, the list of things which are capable of being causes of force majeure. Now, obviously, the laundry list may vary from force majeure clause to force majeure clause, but nothing really turns on that in this appeal. A couple of points just to note about 36.3a, b and c. 36.3b. The tribunal found as a fact that 36.3b was satisfied. In front of Mr. Justice Jacobs, RTI raised a variety of arguments about causation to suggest that, in fact, there had been no prevention or delay here, either as a matter of law or as a construction of a particular clause. Mr. Justice Jacobs rejected all of those arguments, and there was no appeal against that. Perhaps the other thing just to note about 36.3b while we have it open is that RTI's case at paragraph 30.3 emphasises the reference to loading of the cargo at the loading port and or discharge of the cargo at the discharging port. And what RTI suggests is that that wording implies that loading and discharge might take place at other ports than the loading and discharging port, and that supports their case that reasonable endeavours may extend to variation or non-contractual performance. Now, I submit that's not the right reading of the reference to loading and discharging point. The real significance of the reference, I suggest, is this. The ports which are being referred to there as the loading and the discharging port, those are the ports specifically referred to in the recap, Conakry and Dnipro-Bugskry. And the point that clause 36.3b is really making, I would submit, is that an event or state of affairs will only qualify as force majeure if it prevents or delays operations at the contractual ports. That is to say, an event or a state of affairs only qualifies as force majeure if it interferes with performance of the contract according to its terms. That's a point that I'll develop when I come to some points of principle, but I do submit that the fact that the force majeure clause only responds to impediments to performance of the contract according to its terms has implications for the scope of the RE proviso. Clauses 36.4 to 5 deal with the requirement for a party who wishes to rely upon force majeure to give written notice. Nothing turned on that in this appeal. One thing which is quite interesting, I would suggest, about the force majeure clause as your lordships have it at page 275 is that there isn't any reasonable endeavours proviso. that the reasonable endeavours proviso under which the question of law arises is inserted as an addition in the recap. And your Lordship will see that back at page 264. And where it says others as per executed Charter Party, it then says with agreed amendments as below. And near the bottom, one of the agreed amendments is page 8, clause 36.3, add D, and that's the force majeure provision.
So, could you take us through that again, please? I was fine.
Yes, my Lord. Page 264.
Yes.
It's about 6 lines or so from the bottom, and it says page 8, yes. Clause 36.3, add D.
Yes.
It cannot, and that's the force majeure. That's the reasonable endeavours proviso.
Yeah. So we read that into as a new D. Yes.
Yeah, my Lord. It gets added in to page 275 after 36.3C, so that 36.3 ends up with 4 subparagraphs, the original 3.
But would I be right in thinking, in saying that such a reasonable endeavours clause is normal in a force majeure clause?
Well, the point, my Lord, I was going to make was this. It's interesting that it's not there in the clause as it was written,
yes,
because it rather suggests that the person who wrote the clause, obviously some thought was given to this clause. It's a carefully drafted clause. It's complex. It's a page long. The person or persons who drafted it, they didn't think they needed an express reasonable endeavours proviso. And in my submission, they're right, because one of the points I'll be coming on to is that
you say it's implied. It's
implied.
All force majeure clauses because of your argument on causation.
My Lord, yes. And in my submission, whoever didn't think that they needed an express RE proviso was quite right. And indeed, they didn't really need 36.3A either, because a reasonable control proviso will be readily implied for precisely the same reason. Now, your Lordships have the full force majeure clause with 36.3D written into it, for convenience set out in the Statement of Facts and Issues, which is at page 53 of the core volume. It's at para 11 of the Statement of Facts and Issues. While we've got the clause open, perhaps I may as well just make this point now. Your Lordships will see that 36.3A, B, C and D, the 4 definitions, as Lord Hamden puts it, of what constitutes force majeure, each one of those subparagraphs begins with the word it. And as a matter of language, context, syntax and construction, it cross-refers back on each occasion to the event or state of affairs which is mentioned in the first sentence of paragraph 36.3. And that means that clause 36.3D is concerned with whether the relevant event or state of affairs can be overcome by reasonable endeavours. And that point explains why Lord Justice Mayles rejected RTI's case in the Court of Appeal. RTI have a broad case and a narrow case. The broad case, I think, is perhaps most clearly stated at paragraph 10 of their case. And it says that if there is a way of resolving the delay or prevention of cargo operations which requires no more than reasonable endeavours, then clause 36.3D is potentially in play, and it's not fatal, RTI says, if the proposed solution would involve a variation or non-contractual performance. That just goes to what is or is not reasonable. That's RTI's case. And the narrow case is a variation on the broad case. And that means that both the broad and the narrow cases propose that the critical question under clause 36.3D is whether a proposed solution will resolve the delay or prevention of cargo operations. There's a laser focus on the prevention or delay of the cargo operations, and if the proposed solution will resolve the prevention or delay to cargo operations, then it doesn't necessarily matter that the solution will not overcome some other aspect of the event or state of affairs, such as the fact that it interferes with contractual payment. That, again, just goes to cargo operations. The key, to reasonableness, forgive me, the key concern on RTI's case is always prevention or delay to cargo operations. And the problem is that that doesn't work just as a matter of construction, because the it, which appears at the beginning of A, B, C, and D, does not refer to prevention or delay of cargo operations. And prevention or delay of cargo operations does not constitute force majeure. Under 36.3b, prevention or delay of cargo operations is a necessary consequence of the thing which does constitute force majeure. But the thing which does constitute force majeure is the it, which is referred to in each of these subparagraphs, and the it is the event or state of affairs, not just one particular consequence of it. And that means that the correct reading of 36.3d is that it's only engaged if the event or the state of affairs can be overcome. And that means...
Sorry, I didn't hear that. Only if the event or state of affairs...
Can be overcome, I'm sorry, my lord.
Yeah, thank you.
And that means, I submit, overcoming the event or state of affairs as a whole, or at least overcoming its effects as a whole. It does not just mean overcoming the prevention or delay of cargo operations. Now, this is a point which Mr. Justice Jacobs made at first instance. This is his judgment at paragraphs 113 to 114. He said that the it, which is referred to all the way through clause 36.3, is the event or state of affairs.
So the paragraph number?
113 to 114, my lord.
Thank you.
Page?
It's page 186 of the core volume, my lord. And Mr. Justice Jacobs said for that reason it's too narrow and to ask the wrong question just to look at the prevention or delay of cargo operations. And Lord Justice Mayles says very much the same thing in his judgment at paragraph 48, page 160 of the core volume. He makes the same point that the it is the event or the state of affairs. And he said at paragraph 52 that the problem with both the narrow and the broad case on RTI's part was that they don't focus on what effect the reasonable endeavours would have on the event or state of affairs. They just focus on one aspect. And that's not what the wording says. And in my submission, Mr. Justice Jacobs and Lord Justice Mayles were right about that. And that means that RTI's own case, whether broad or narrow, fails just as a matter of wording and construction before one considers the points of principle and authority, which I'm going to come to. Though I submit that those points of principle and authority are in any event an answer both to RTI's own case and to Lord Justice Mayles' independent alternative analysis. Now, my lords,
can I just be clear that I've got this right? You're saying there's a completely separate reason why this appeal should be allowed. Is this right?
No, my lord. There's a separate reason why RTI's broad and narrow case are wrong.
Fails.
But bearing in mind that Lord Justice Mayles said they were wrong anyway, that only takes one so far. I make that point because RTI say they're going to revive those points on this appeal.
Right.
And I simply make the point that Mr. Justice Jacobs and Lord Justice Mayles were both correct, that it does not work as a matter of construction. But I'm still left with Lord Justice Mayles' independent reasoning that I have to tackle. Though I say that the points I'm going to make answer both Lord Justice Mayles' independent reasoning and RTI's case.
And the event or state of affairs that's the it yes. on your submission is what?
Well, the tribunal didn't you may have seen the comment my Lord Justice Mayles in the Court of Appeal. They had an awful lot of issues to decide, many of which had absolutely nothing whatsoever to do with force majeure. Much of their reasoning is very compressed. They found that clauses 36A, B, and C were all satisfied because they said that the only reason we failed on force majeure was because of clause 36.3D. There's no appeal against the finding that A, B, and C are all satisfied. They don't explicitly spell out which of the events on the laundry list they held had occurred. But given their findings of fact, the problem was that RTI was not able to make timely payment in US dollars. The reason that RTI could not make timely payment in US dollars was what Lord Justice Newey called friction in the banking system. The friction in the banking system was that although the tribunal found that as a matter of US law, it would have been lawful for banks to make dollar payments on ITI's behalf, it also found that as a matter of practicality, because US sanctions are very drastic, anyone would have been cautious and nervous about dealing with a sanctioned party. And therefore, regardless of the strict position in US law, any bank asked to process a payment for RTI would have stopped the payment in order to investigate, a dollar payment, that is. And that would have impeded RTI's ability to pay dollars on time under the contract.
Is any of this contested now?
I hope not, because I hope it's all the statement of facts and issues.
Yeah, well, quite.
What are the particular findings you remarked?
Well, my Lord, if one wants to look at it in the award, which is where the actual findings are, the award begins at page 198. Perhaps it's convenient to begin at page 211. And at paragraph 26 on page 211, your Lordships have the force majeure clause which MUR sent after the US sanctions had been imposed in April 2018. And in the first paragraph, MUR note that as UC Rusal has been sanctioned, and as RTI are a subsidiary of UC Rusal, charterers are similarly be treated as if they're named on the list. That's an implied reference to something which is called the 50% rule, the effect of which is that if Company A is sanctioned in the States and it owns 50% or more of Company B, then Company B is treated the same way. So the first point is that RTI are caught by the sanctions imposed on its parent, UC Rusal. And then MUR, in the force majeure notice, asserted that there were two consequences of that. The first, it would be a breach of sanctions for owners to continue with the performance of the contract, i.e. that as a matter of American law, MUR would itself be breaking the law if it continued to perform. That was one point. And then the other point over at 212, near the top of 212, is that sanctions will prevent dollar payments which are required under the contract. RTI did not accept that either of those were correct. And the tribunal had expert evidence from US lawyers about the position in US law, and they refer to that at paragraph 33. They go through some of the statutory background at 34 and 35. They refer at 36 to a general license 12, which was issued at the same time as the sanctions. And the broad effect of it was that specified activities were permitted by way of exception to the sanctions under existing contracts. And at paragraph 41 at the bottom of 216, the tribunal preferred the evidence of Mr. Smith for RTI, and without going into the nitty-gritty, what he said and what the tribunal accepted was that continued performance of this contract would have been permissible under General License 12. So, as a matter of strict US law, RTI's contention that it will be a breach of sanctions to continue with performance of the contract was wrong. And furthermore, if your lordships go to page 218, paragraph 44, as a matter of US law, MUR's alternative case that it would not be possible to pay US dollars under the contract, that was wrong too. As a matter of US law, there was no prohibition either on performing the contract or on the payment of dollars under the contract. So that was the strict US legal position. The factual position was a bit different, because you see there at 45 that the experts were agreed that if dollars had to be paid through a US intermediary bank, and it was highly likely that that's how dollar payments were processed, then it was highly probable that the bank would stop the transfer because RTI was sanctioned, in order to investigate whether the transaction complied with the sanctions. And then there's a separate point at paragraph 46 that virtually all US dollar transactions are routed through US banks. So in practice, one couldn't get round that difficulty by routing the money through somebody else.
There's also paragraph 43.
45 and 46, I was up, my lord.
Also 43 is right,
yes.
Isn't it?
Yes, indeed. And that's the general point, that people are very nervous and frightened of trading with sanctioned parties. And while your lordship is looking at paragraph 43, I just make this point. A degree of hay is made by RTI about the fact that even Lord Justice Arnold, who held in our favour in the Court of Appeal, said that we had, quote unquote, no merits. Now, it's not really very clear why we're thought to have no merits when you read paragraph 43. The tribunal didn't say we had no merit. On the contrary, the tribunal said, although it's a matter of common sense, that anybody trading with a sanctioned person, and we were trading with a sanctioned person, we had this contract with RTI, is going to be nervous and frightened and exercise extreme caution. We might perhaps have hoped, with the tribunal making that finding, that the tribunal would not have gone on to say, but nevertheless, MUR ought to have realised that the thing to do to get round all these difficulties was to immediately agree to accept payment in euros instead of US dollars. Unfortunately for us, the tribunal did make that finding. We'll come to it in a moment. But they did not say that we had no merits. And indeed, they said at 43 that we were prima facie entitled to stop and consider the position. Now, after 45 and 46, so the factual position is that notwithstanding the strict legal position in US law, payments are going to be stopped for investigation. So at the very least, they're going to be delayed. And RTI are not going to be in a position to make timely dollar payments, and it's a dollar contract. And then the finding on which we lost before the tribunal comes after, at paragraph 47, they set out the regional endeavours proviso, And then the critical finding is at paragraph 50. RTI had offered to pay us in euros rather than in dollars, and they had also offered to pick up any exchange rate losses that we suffered in converting the euros into dollars or any additional expenses. And the tribunal's finding at paragraph 50 was that we should reasonably have accepted that offer. You'll note that the tribunal accepts that RTI could not insist on making payments in euros because it's a dollar contract. As I've already said, there's no appeal against that. But it was the tribunal was satisfied a completely realistic alternative, and there had been no detriment to us. And therefore they held that we should have done it, notwithstanding that because it was a dollar contract, it would have involved a variation or a non-contractual performance. And then the upshot of the whole thing at paragraph 51 was that we succeeded in all other respects, apart from that. So that means that the tribunal found that we had satisfied 36.3a and b and c, but we fell at the final hurdle at D on the facts.
I mean, the judge explains why 36.3c satisfied at paragraph 133.
Yes.
His judgment.
And there are
189, I think.
yes. In the Court of Appeal, it's fair to say that Lord Justice Mayles was a bit puzzled in particular about C. But he said there was no appeal against it and therefore he wasn't going to go into it. But when one sees the facts, the problem, as I say, was what Lord Justice Newey calls the friction in the banking system. That is to say, RTI were unable to make timely contractual payment. That was as a result of the attitude of the banks stopping payment. And that, in turn, was a result of the sanctions. And so, in answer to the question that my Lord Burrows asked a few moments ago, I would suggest that the analysis is the event or state of affairs is RTI's inability to make timely payment. And in terms of the laundry list, what is it that's causing the event or state of affairs? Either the sanctions are interference or acts or directions of government, or the friction in the banking system is a restriction on monetary transfers and exchanges. Well, Justice Mayles made a point about, well, there was no legal restriction, and that's right, but it doesn't say legal restriction, and there was a factual restriction if the banks were going to stop payments in order to investigate.
Paragraph 52 of the award is illuminating on this, because the issue arose as to whether the force majeure notice was sufficient, and the tribunal held that it was, because the details that mattered were the imposition of sanctions.
Yes. Lord Justice Mayles' point about that was, well, the sanctions are on the laundry list, but the laundry list refers to cause. What causes the event or state of affairs? So Lord Justice Mayles said, well, the sanctions can't themselves be the event or state of affairs, and maybe that's right analytically, but we would submit that the sanctions are within the laundry list, and the event or state of affairs that they cause is the friction in the banking system. You can fit the fact into.
Well,
without too much.
It's, as you put it, the inability to pay.
Yes.
Which was a practical inability rather than a legal inability.
Not legal, but it never.
But caused by the sanctions.
Caused by the sanctions.
Thank you.
Or caused by the banks being extra cautious, and that's a factual restriction.
Yes.
Now, I was going to say something about the facts anyway. The one thing out of all that I want to emphasise is we did get into a bit of a pickle in the Court of Appeal about the facts, because again the findings are rather compressed, and there was a question at large asked by Lord Justice Newey and there's an echo of it in, I think it's footnote 2 in RTI's case, where there's a statement that RTI always said that it could pay in dollars, and the tribunal rejected MUR's case that payment in dollars would be impossible. Now, one just needs to take that a little carefully, because one sees from the award there are two separate strands. One is it legally impossible? And the answer to that was no. We lost that. That part of our case was rejected. But nevertheless, factually, it's a different matter. It was not factually possible. And as the Court of Appeal ultimately said, after we've been through the award in some detail, there is a clear finding that it was highly probable that US payments would at the very least be delayed. That's paragraphs 22 to 23 in the Court of Appeal.
Well, the effects of the sanctions are set out in the Statement of Facts and Issues as agreed.
Yes.
In paragraphs 25 to 29.
My lord, that is right. And so it is agreed that there was a practical problem, even if there wasn't, in a matter of strict US law, a legal problem. So, my lord, that's the contract. Those are the facts. We rely on 4 points of principle and primarily 2 authorities. Subject to your lordships, I was going to take matters in the order which we've dealt with them in the case, which is principle then authority. And the reason for that is that there is no case which states expressly and in terms that an RE proviso doesn't extend to variation or non-contractual performance unless it says so. I submit that Bullman and Fenwick and the Vancouver Strikes cases, the reasoning in them points in that direction and supports the conclusion which would follow from points of principle. But since they don't say it expressly and in terms, and if they did, we probably wouldn't be here, and since they say they support the points of principle, I was going to start with the points of principle first. And we make 4 points of principle, which we submit do point to the conclusion that an RE proviso does not extend to variation or non-contractual performance unless it says so.
And these are the points set out in paragraph 43.
Yes.
These are the points points of principle set out in
Sure, your
paragraph
lordship is
43 of your written case.
My lord, those are they. Now, the 4th, I've really already dealt with that in showing your lordships clause 36.2. And I probably don't need to add to it. Your lordships have the point. Clause 36.2 expressly mentions the possibility that change may have to follow in response to force majeure. The parties could have said something functionally the same or similar in 36.3d, and they didn't. And then the judge, in his judgment, suggested that that was a marginal matter, I think he called it. Paragraph 110 to 114, where he addressed that, Lord Justice Mayles didn't expressly deal with it at all. I submit it's more than marginal. It shows that the parties gave mind to the possibility that things might have to change in response to force majeure. They catered for it expressly in 36.2. They said nothing about it in 36.3d. And I submit that when you see that they spoke up about it in 36.2 and were silent in 36.3d, then the silence becomes a speaking silence. Because to paraphrase Lord Hoffman in Belize Telecom, if the parties intended change to happen or potentially happen under 36.3d as well as under 36.2, then they'd have said so under 36.3d as well as under 36.2. And the implication from the fact that they didn't say it in 36.3d is that they didn't intend it in 36.3d. And when the parties chose not to expressly include provision, there is in my submission no reason why the court should in effect imply provision, and indeed every reason why the court shouldn't. So it's a short point, but I submit it's nonetheless valid for that, and perhaps worth a little more than Mr. Justice Jacobs attached to it.
Sorry, I just didn't hear that last point.
Sorry, I suggest, my Lord, that it's a valid point and worth perhaps rather more than the significance which Mr. Justice Jacobs attached to it when he called it marginal. I mean, it's actually quite a powerful indication, on the face of it, that the parties didn't intend the same thing to happen under 36.3d as was going to happen under 36.2, because if they did, they'd have said so. So that's the fourth point out of the way. The first point of principle is a point about what I submit as the purpose of reasonable endeavours provisos. I advance two propositions which are perhaps not very often expressly articulated in the case law, but perhaps that's because they're really rather obvious, but they're nonetheless relevant. The first proposition is that force majeure clauses are directed to a situation in which a specified event is impeding performance of the contract, same as accepted perils clauses. And the second proposition is that when one says impeding performance of the contract means performance of the contract according to its terms. I've already submitted that clause 36.3b, with its reference to at the loading port, at the discharging port, emphasises that. It indicates that you're looking at interference with contractual loading at the contractual loading port. And putting those two propositions together, an event or a peril which does not impede performance of the contract according to its terms, I would submit that does not engage a force majeure or a perils clause, unless perhaps the clause is written in a rather idiosyncratic fashion, which this one isn't. And that may sometimes make it necessary to look at the contract quite closely to work out, well, what exactly is involved in performance of the contract according to its terms, because you may need to answer that quite precisely before you can say, well, is this event impeding or interfering with performance according to the terms in a way which engages an FM clause or a perils clause? And that particular point is illustrated by the cases about alternative performance. We've set this out in our case. I don't think any point of principle is taken with what we say, so I'll try and summarise it. These are probably familiar to the court, but these are the cases where, on the face of it, the contract appears to contemplate that the performing party may perform in alternative ways. And the law has divided the cases into cases which concern what's called a performance option and cases which concern what's called a contract option. And if it's a performance option, then the obligee has to render either of two modes of performance, and it gets to choose which. So the classic obligation to load a cargo of wheat or to load a cargo of flour. And you've got to load one or the other, but you get to choose which. And if that is the type of contract you have, then the significance is this. The fact that an event or a peril affects one of your choices won't relieve you under an FM clause or an accepted perils clause if you can still do the other thing. And the reason for that is that the event or the peril is not impeding contractual performance, because it's still possible for you to perform in accordance with the contract. If you are obliged to load a cargo of flour or a cargo of wheat, and for some reason you can't load a cargo of flour, then your obligation narrows to an obligation to load a cargo of wheat, and that's what you've got to do. And as long as you can load a cargo of wheat, you can't rely upon force majeure or an exception, because it's still possible for you to perform that contractual obligation. It's possible for you to perform the contract.
Where does the language of performance option and contract option come from?
Chitty, I believe.
Right, it's different to Lord Devlin.
Lord Devlin calls it a business option. Some people refer to a true option against a business option. There are various ways of putting it. I think that performance and contract is the chitty, one of the textbooks, my lord. And it's the terminology that I've used just because I'm familiar with it. But your lordship is right. There are other ways of expressing it. But the concept remains the same, whichever you call it.
But I think we just have to be clear. Your contract option is what Lord Devlin was calling, I believe, the business.
A business option.
Yeah.
And he would call
a true option, so to speak.
A true, and some people call it a true option.
Yeah.
And I think he contrasts a business option with an option in everyday speech or everyday language or something, which is quite a long way of putting it. So I've called it a performance option. The point being that the option is that you've got a range of possible modes of performance and you have to choose one. And the point for present purposes being that the fact that one of them becomes impeded doesn't give you a defence under a perils clause or an FM clause if the other one is still possible. As Lord Devlin put it, I think probably in Vancouver Strikes, if one of your options is damned, then the flow of performance is merely redirected towards the other. So if you can't load wheat, but you can load flour, then you've got to load flour. And just ask your lordship to note this, that's not because of anything to do with a reasonable endeavours proviso to the accepted perils clause or the force majeure clause. It's not that you're under an obligation to exercise reasonable endeavours to load wheat if you can't get flour. You just have to do it because that is the contract. You load wheat, you load flour. You can't get wheat, you've got to load flour. It's not about reasonable endeavours.
So in what you refer to as a performance option, the contractual obligation extends to different ways of performing it.
Performing, indeed. And as long as one of them is available to you, you must perform, and that is performing the contract, and therefore you're not entitled to rely upon an exceptional peril. But by contrast, in a Lord Devlin business option or a contract option, there is a different sort of choice. What you have there is, as it were, a default obligation and an option to change it. So, an obligation to load a cargo of flour, charterer's option to load a cargo of wheat instead. And that was the conclusion of the nature of the contract in Vancouver Strikes. And the position there is that unless and until the option is exercised, it's a wheat contract. And that's the obligation, is to load wheat. And if you can't get wheat, then you are entitled to say that there is an impediment to performance of your contractual obligation, because if you haven't exercised the option, your obligation is to load wheat.
So an example would be an option to substitute.
Yes, substitute a vessel, perhaps, my lord, yes. And one does sometimes get questioned about whether if the original vessel sinks or is damaged, are you under an obligation to substitute? It comes down to a question of construction as to whether that is a performance option or a contract option. And ultimately, it is a question of construction. But that's a possibility. And those two possibilities are illustrated most famously by Brightman and Bunge and Bourne, where it was held that an obligation to load wheat or flour or barley was a performance option, and if you couldn't get wheat, then you had to load barley or flour instead, and you couldn't cry force majeure or an exception. And the contract or business option is illustrated by Vancouver Strikes, where it was an obligation to load wheat, charterer's option to load barley or flour. And the House of Lords said, well, that's a wheat contract. And it remains a wheat contract unless the obligation is exercised. And if you can't get wheat, then you can rely on a force majeure clause or an exceptions clause. Now, we set that out with some textbook references in our case at 47 to 49. The RTI, I don't think, take any point with the principle. The question really is what significance does one draw from it in this context? And I submit that the significance is that it does, in my submission, bear out my points that a perils or force majeure clause is concerned with a situation in which there's an impediment to performance according to the contract terms. That's the very reason why in these cases you have to identify, is it a contract option or is it a performance option? And if that's right, if they reinforce the point that the clause is directed to interference with performance of the contract according to its terms, and that's the territory with which a force majeure clause is concerned, then logically, I would submit it follows that the object of a reasonable endeavours proviso is to secure the continuation or resumption of performance of the contract which is being, of the performance which is being impeded, that is to say, performance according to the terms. Putting it another way, a reasonable endeavours proviso requires, or may require, a response to a force majeure event or an accepted peril when it has happened. The object is to overcome, using the word in 36.3d, the force majeure event or the peril or its effects. And since the significance of the force majeure event or peril is that it's impeding performance of the contract according to its terms, the reasonable endeavours response should only be relevant or required if it will facilitate continuation or resumption of that performance, that is to say, performance according to the terms. Variation or non-contractual performance just doesn't come into it. It's not relevant. Concern is performance of the contract according to its terms. And I submit that that is then reinforced by the consideration that reasonable endeavours provisos, as my Lord Hodge said a while ago, they go to causation. That's what they're concerned with. I've already said that if there hadn't been 36.3d here, and there wasn't originally, a reasonable endeavours proviso would very readily have been implied, as indeed would the 36.3a reasonable control proviso. We have set out in our case at paragraphs 27 to 38 authorities and textbooks supporting the proposition that these things will be readily implied. Again, I don't think any issue is really taken with that by RTI. Indeed, I think they accept that Bullman and Fenwick is one of the authorities for that proposition. What one doesn't very often see in the material which we have referred to is an articulation of, well, why? Why does the law readily imply reasonable endeavours provisos and reasonable control provisos? And the answer in my submission is that it goes to causation. It does from time to time emerge in the authorities. In particular, I think in Scotland, talking about exceptions clauses in charter parties and Lord Sumption's judgment in Volcafe. But even without such occasional trips out into the light, I submit it's plain when one thinks about it the essence of force majeure or accepted perils is that the parties are excused when their performance is being impeded by a force majeure event or by an accepted peril. There is an inherent requirement for causation between the non-performance and the peril or force majeure event. And on normal principles, the required causation is effective cause.
What are the references to where you say this has been at least tangentially addressed?
Well, in the Supreme Court in Volcafe and Sud, paragraph 32 of Lord Sumption's speech.
I'm sorry, which is... Oh, I've got it. Yes, Volcafe.
Page.
Page...
It starts at 1200.
1200, and I'm afraid I don't have the page at which paragraph 32 is, my lord. 1222, I'm told. And then also, for your lordship's interest, Scrutton, paragraph 11.31 to 11.32, that's in the authorities bundle at 1451. And I think also Carver at 9.217 in the authorities bundle at 1365.
Can you just give the Scrutton reference again?
My lord.
Page. Just
page 1451, para 11.31.
And Carver again, please.
And Carver 9.217, paragraph that is, and page 1365.
Thank you very much.
And they all make the point, the traditional statements that the carrier's duty is to exercise skill and care in carrying the goods, and unless prevented by the accepted peril, and that implies causation, and if the accepted peril could have been overcome by reasonable endeavours or avoided by reasonable endeavours, then causation simply isn't established. And that's the point. If you are, as a contracting party, going to say, well, I was prevented or impeded by the peril or event, then you're asserting a causal connection. And that can be answered by saying, well, no, you could have avoided or overcome the problem by reasonable endeavours. And therefore, the effective cause really is not the peril or event itself, it's just your own inadequate response to it. And the perils clause or the force majeure clause does not protect you against your own inadequate response.
Do you say accepted perils clauses and force majeure clauses should be treated in exactly the same way for these purposes?
The question, my lord, of whether and to what extent there really is a difference between force majeure clauses and accepted perils clauses, whether a force majeure clause is just an accepted perils clause that uses the word force majeure, but perhaps your lordships don't have to decide it on this appeal. I'm not sure what the answer is. They certainly shade into one another to this effect, that in relation to the implication of a reasonable endeavours proviso, yes, in my submission when one looks at the materials, they can be treated the same. Now, one of the cases which we've relied upon for the principle is B&S Contractors and Green. Now, the clause there was headed force majeure. But Lord Justice Carr, I think at least twice, says it's an exceptions clause. Now, you can see why. Because both of types of clause, if they are different types of clause, are concerned with relieving you from performance or liability when your performance is impeded by particular things. In one clause, it's called an accepted peril. In the other clause, it's called a force majeure event. But whether that may just be a matter of terminology. But in relation to this aspect of reasonable control and reasonable endeavours provisos, then yes, I do submit that one can see they are the same.
And I'm right in saying, I think, that the Bullman case and the Vancouver strikes case that you rely on, they are indisputably accepted perils cases, but there might be an argument as to whether they are force majeure cases. Is that right?
The clause in Vancouver strikes, one of the what your lordship would call accepted perils, was force majeure.
Yeah.
And again, one can, are they different?
At least in Bullman, I think it's referred to as an accepted perils clause.
An accepted peril.
Yeah.
And Bullman is a classic charter party exceptions to the running of lay time.
Yeah.
I don't think it says accepted peril. I think it just says this time is accepted. But yes, it uses the word of exceptions. It doesn't state force majeure. In Vancouver Strikes, it uses the word of exceptions, but one of the things that constitutes an exception is force majeure.
And I'm sure you're coming to these cases, but can you just remind me, was there a reasonable endeavours clause as well in those cases? No, in neither.
In neither, and that's why Bullman and Fenwick it's in some ways it's the original authority for the proposition that a reasonable endeavours obligation will be implied, and it's expressly recognised by Lord Esher in his admirably short judgment in the Court of Appeal. And in Vancouver Strikes, interestingly, the Vancouver Strikes contract's a bit like the contract here. There is no reasonable endeavours proviso, but there is a reasonable control proviso. So there's an equivalent of R36.3a, but no equivalent of R36.3d.
Thank you.
And in the Court of Appeal, Lord Justice Arnold recognised, and I submit correctly recognised, that reasonable endeavours provisos, whether express or implied, are matters of causation, because he said this: if the force majeure event can be overcome by reasonable endeavours, then the loss is self-inflicted. And submit that's effectively the language of causation. It's like self-induced frustration, perhaps. Brought it upon yourself, you can't say it was caused by extraneous circumstances. Now, my lords, I submit that if it's right, and I submit it is right, that reasonable endeavours provisos are directed to causation, then that tends to confirm that they are not concerned with and they don't extend to matters of variation or non-contractual performance. Because the causal inquiry under a proviso, whether it's express or implied, is whether the effective cause of the relevant condition is the event or peril itself or the affected party's inadequate response to it. The relevant condition is, again, an impediment to performance of the contract according to its terms. So the causal inquiry is what is causing that impediment, what's impeding that performance according to the terms. If one puts the question, did the friction in the banking system in this case cause an impediment to performance of RTI's contractual obligation to pay in dollars? That's putting it in causal terms. If one puts it that way, it's not an intelligible answer to say, well, no, it didn't, because it would have been reasonable for RTI to accept payment in euros instead. That answer just completely misses the question. It's the answer which Lord Justice Mayles is... Forgive me.
Sorry, the question is defined by reference to the contract terms themselves.
Yes, because in my submission, the causal question is directed to that, because the FM event, or what triggers the clause, the FM clause or perils clause, is something which is impeding performance of the contract according to its terms. I've been through that. And if the causal question is, well, what is causing that, then the question is, was the friction in the banking system causing RTI to be unable to make timely payment? It's not an intelligent answer to say, no, it's not, because you could have paid non-contractually. It just misses the question. It misses the sense of the question altogether. But the logic of Lord Justice Mayles' analysis is that that's a sensible answer. He says it's the right answer. And in my submission, it's not the right answer, it's not a sensible answer, it's an irrelevant answer. And I do submit, having mentioned Lord Justice Arnold, it's interesting to note, and it's significant to note, that Lord Justice Arnold did make this inquiry into, well, what are reasonable endeavours provisos for, and came to the conclusion that well, if you could have avoided the problem by reasonable endeavours, then it's all self-inflicted. And he came to the conclusion that the reasonable endeavours proviso does not extend to variation or non-contractual performance. And by contrast with that, Lord Justice Mayo said he never asked the question. He never considered what is the clause for. And I submit that that's rather a large oversight in a case which is concerned with, well, what are the limits of the clause? It's not even asked what its purpose is. And the fact that RE provisos, whether express or implied, and whether in force majeure clauses or accepted perils, the fact that they're all concerned with causation also has this further point and significance in my submission. It undermines Lord Justice Mayall's thinking that one has to focus very narrowly on the particular words of the particular clause, so that this case is all about overcome. Because that way of thinking does rather imply that each reasonable endeavours proviso is sort of an island, operates within the parameters of its own words, and it's cut off from other clauses which have different wording. But if it's right, and I submit it is right, that all RE provisos are ultimately concerned with causation, that's not a plausible analysis in my submission. If they're all concerned with the same thing, you don't realistically expect that their effect is going to change dramatically with subtle differences in wording or depending upon the particular verb which the parties to a particular contract happen to choose. It would not have made any difference, I would submit, to this case if the parties, instead of overcome, had used neutralise, nullify, negate, or anything else. Indeed, one of the cases we've got, I won't ask you to look it up, but Seadrill and Tullow, beginning in the authorities bundle at 952, there's an express reasonable endeavours clause there which refers to endeavours to mitigate, overcome, circumvent or avoid. An example of what Lord Hoffman would call the draftsman's determination to obliterate the target. Yeah, but it's not realistic to think, in my submission, that chucking all those words in will lead to a different conclusion from if you just use one of them, when one understands that what one is looking at is effective cause, and that these words are all just covering the effective cause inquiry. And that, for that reason, it's misconceived in my submission for Lord Justice Mayall to go down the narrow route of saying, well, it all depends upon testing the limits of the verb overcome. So, my Lord, just to draw on to a halt on this first point, and then that might be a good moment for the break, I do submit that Lord Justice Mayall's took a wrong turn in going straight into the word overcome and thinking about, well, what does that mean and how far can one push it, without standing back to ask the question, as Lord Justice Arnold did, what's this clause for? And if he had stood back and asked the question, he would, like Lord Justice Arnold, have realised that this proviso, like other provisos, express or implied, is directed to causation. You're concerned with what it is that is causing an impediment to contractual performance. And that non-contractual performance and variation just don't come into it. Non-contractual performance wouldn't be relevant if one was deciding, has the clause been triggered in the first place? You can't trigger a force majeure clause or an accepted peril clause by saying, well, I'm not able to do X if X isn't required under the contract. And logical consistency suggests that variation and non-contractual performance equally don't come into it when you're looking at it from the perspective of the reasonable endeavours proviso. It's just outside the scope. And it's outside the concern. The concern is causation. So, my Lords, if that would be a convenient point for 10 minutes, I'll come back and start on the next principle.
At the party's request, the court will now adjourn for 10 minutes.
Yes, my Lords, my second point of principle, I hope, will be a relatively short one. Certainty is important, particularly in commercial contracts, and therefore, all other things being equal, the answer to the question of law should be as simple as it can be for commercial parties to understand and to apply when issues like this arise in other contracts and other transactions. And I submit that our proposed answer will promote greater certainty than either RTI's answer or Lord Justice Mayall's answer. Our proposed answer is simply this. A reasonable endeavours proviso does not extend to variation or non-contractual performance unless it says so. And therefore, if one is faced with a reasonable endeavours proviso which doesn't say so, then if we are right, there is a single threshold question. Does any proposed solution involve variation or non-contractual performance? If it does, then it's outside the scope of the clause, the reasonable endeavours proviso, and you can forget about it. Now, RTI say, well, sometimes it may not be very simple to work out whether a particular solution would involve non-contractual performance or variation. You may need to think about the contractual terms quite carefully. And that's fair so far as it goes. It'll be more straightforward in some cases than others. But nevertheless, the point remains that it's a single threshold question. Whereas on both RTI's case and Lord Justice Mayall's analysis, you have to go on to ask additional questions, as well as the threshold question. Because if one takes RTI's case, as noted by Mr. Justice Jacobs and also by Lord Justice Mayall's.
You say that case, you're talking about the broad and narrow.
I think for these purposes it doesn't matter, my Lord, because the narrow is a...
You're taking back those two
taken
cases.
together, yes, right. Yes, my Lord. Mr. Justice Jacobs at paragraph 85 and Lord Justice Mayall's at paragraph 33 record that RTI's case is that if a particular solution would involve variation or non-contractual performance, then that bears some significance. It does bear weight, RTI say. It's not definitive, because ultimately everything comes down to a question of reasonableness, but the fact that the solution would involve variation or non-contractual performance bears weight in putting everything in the scales to work out what is and is not reasonable. So, if that's right, you still have to ask the threshold question, because if the solution would involve variation or non-contractual performance, then you have to give due weight to that in the balancing act. So you don't get out of the threshold question. It's just that you then potentially have to go on and perform a second assessment, which is the balancing act, which all comes down to, well, what's reasonable. And that, in my submission, does not promote certainty if it all comes down to what is reasonable. And it was an approach which did not appeal to Mr. Justice Jacobs or to the Court of Appeal. So Lord Justice Mayall's adopted his alternative approach, but on Lord Justice Mayall's approach, there are three questions which one has to look at. One sees that from paragraphs 56 and 57 of Lord Justice Mayall's judgment in particular, because Lord Justice Mayall's essential proposition is that you have to apply clause 36.3d in a way which, quote, achieves the purpose underlying the party's obligations. Now, if that is right, then logically the first question you have to ask yourself is, well, what is the purpose underlying the party's obligations. And Lord Justice Mayles came up with what he thought was a satisfactory answer in this case. And apparently the inquiry is broad, non-technical, and common sense. Now those phrases all sound very happy and encouraging, but they don't really give you very much guidance in what it is that you are looking for when you are trying to identify the purpose underlying the contractual obligation. For example, Lord Justice Mayles said the purpose underlying the contractual obligation here is that RTI should receive the right amount of dollars at the right time. Now, I would, with respect, admit that that is just a rather weaselly way of saying that the purpose was that RTI were obliged to pay in dollars, which is what the contract says. So why not just say it? You know, why do you go beyond what the contract says in looking for a purpose? But according to Lord Justice Mayles, you must identify a purpose. So that's question number one. And question number two is, having identified the purpose, you've got to ask yourself, well, does this proposed solution achieve the underlying purpose? Now, again, presumably this is a common sense question to be approached in a broad and non-technical way. It's rather open textured. It raises points which Lord Justice Mayles did not answer. What does achieve mean? Achieve precisely the underlying purpose, or is there a tolerance? If there's a tolerance, is it a de minimis tolerance, or is a reasonable correspondence with the purpose sufficient? Whether it's de minimis or reasonable correspondence, neither of those is particularly defined or specific. Neither gives you a great deal of guidance. And then the third question on Lord Justice Mayles' approach is, well, if you identified the purpose and you have decided that the solution will achieve the purpose, then the next question you've got to ask is, does it result in any detriment? And again, presumably detriment is a broad common sense, non-technical concept. And again, there are potentially unanswered questions. Does the detriment have to be detriment that's directly related to the performance of the contract, or would some more remote indirect detriment count? Is there a de minimis threshold? What counts as detriment? It's a fairly nebulous concept. And all of these questions appear to be questions which may involve factual inquiry, in particular into detriment, but you may need to look at matrix evidence to decide what the underlying purpose of the contract is. You probably need to look at factual evidence to decide whether or not the purpose has been achieved. So that they involve questions of inquiry, investigation, and evaluation. And they're all questions, I would submit, which are likely to be rather open-ended and on which reasonable parties or reasonable arbitrators or even reasonable judges may disagree what the answer are. And none of that helps to promote certainty in commercial contracts. It's antithetical.
What do you say about the purpose of the provision that payments are going to be in dollars?
The purpose was that they should pay in dollars, my lord.
Right.
That's, in a sense, it speaks for itself. It's almost artificial to ask what is the purpose of something as simple as that. They were to pay us in dollars and we were to receive dollars. What is achieved is something close to what Mr. Justice Jacobs said at first instance was a different thing legally altogether, which is that they pay the bank, which is our agent, in euros, and the bank converts it into dollars. But as Mr. Justice Jacobs rightly said, if your obligation is to pay in dollars, you don't fulfill that obligation by saying, well, I'll pay your agent in some other currency and your agent can convert it. I submit that that's right, but Lord Justice Mayles' solution effectively comes down to that.
Yes, his solution is that dollars are received by MUR, and he says that that's all that's required.
Via the intermediary of the bank, which is the
intermediary of the bank, making the conversion, and then there's the added.
He says that's good enough.
And there's the added, but there needs to be the added undertaking to meet the costs of the conversion.
Right. Which in a sense shows that the euros element in conversion doesn't get there. There has to be the added on.
Yeah.
And that, in a sense, illustrates the point that you may well have to have a fact inquiry into, well, what is required in order to achieve the purpose once you've identified it, because there may be you've got to have more than simply a payment in another currency, as here. Again, these are...
Your point is this may be a simple case, but the principle being argued against you could give rise to great complexity in other cases.
If it is right, then it could give rise to great complexity. And my learned friends cite a couple of textbooks which they say approve the Court of Appeal decision. Actually, when you read them, it's a qualified approval, because the point is made that these sort of questions arise. How far can you push this achieving the purpose? Does it apply to anything other than payment of money, where there are complications of a currency? Is it workable outside any other context? Could
you just remind me which, when you say books, could you just remind me which?
There is, my Lord, one of them is the latest edition of Mr. Lewison's, Lord Justice Lewison's book.
Right, thank you.
And the other one is, I can never remember who the authors are.
My Lords, we deal with this in paragraph 66 of our case.
Thank you very much.
My Lord, it's the books which are in that paragraph.
Yes, thank you.
Those are they. And if your Lordships look at them, you'll see that there are those qualified questions. And without wishing to be overly glib about it, a serious question to rise as to whether this test is workable outside the scope of this case. And if Lord Justice Mayles has fashioned a principle to fit the facts of this case, then that, in my submission, is simply not appropriate, because it is a question of general principle. And if the decision in the Court of Appeal stands, it will be treated as a question of general principle. That is the basis upon which permission to appeal was given from the arbitrators to the commercial court, and by the commercial court to the Court of Appeal. It will be treated as establishing a general principle, and it's a general principle which in its application is going to be wholly unclear, because it raises these questions. And these are questions which really, when you look at how open-textured they are and the investigation they're going to require, we say in our case, these are really going to be best answered by a judge or an arbitration panel after a hearing, when it's heard all the evidence on matrix and all the evidence on detriment. It's no use as guidance to contractual parties when they've got a dispute. It doesn't help them to say, well, we can see how this reasonable endeavours proviso works. They're going to have to go to law to get an answer. And that is antithetical to certainty in commercial contracts.
So now, it might be said that one's always got a bit of tension about how far one's adhering to absolute certainty, or whether one, to some extent, is prepared to tolerate a degree of uncertainty.
My Lord, that is true.
So if we look at the debate about classification of terms, some people would say, well, the whole development of innominate terms, let's say, is a reflection of the need to look at more factors than simply certainty to the parties at the time. But are we in that territory?
Well, my Lord, the example your Lordship gives, the development of innominate terms since their rediscovery by Lord Justice Diplock, I would submit, has now reached a point where the working presumption is that unless it's been classified as a condition by previous authority, it's an innominate term. So there is a degree of a level of certainty has been achieved. If there are indications in the particular term that the parties intended to treat as a condition, then it'll be treated as a condition. And in a sense, I contend for something similar to that. The working hypothesis should be that unless it says otherwise, the reasonable endeavours proviso simply does not extend to variation or non-contractual performance, and that lends certainty. It's always subject to the
What I really mean is that the fact that the law now may have stabilised as to what classes as innominate terms or conditions doesn't alter the fact that the very test of an innominate term,
I understand, my lord, you're right.
depends on the seriousness of the consequences, which is not as clear-cut as if you were just asking, has there been a breach of condition?
Or indeed, one might say the same in relation to test for frustration.
Yeah.
Yes. I appreciate your lordship's point, and the degree of uncertainty is unavoidable if the old, very rigid law, which treated pretty much everything as a condition entitling the innocent party to terminate the contract, is going to be withdrawn from. But there's no inevitable reason in my submission why one has to introduce Lord Justice Males's uncertain questions into whether or not an RE proviso requires variation or non-contractual performance. There is nothing problematic in my submission with the proposition that we make that it doesn't unless it says so. I come back to my fourth proposition, freedom of contract. If parties don't like that, then they can say it will extend the variation of non-contractual performance. Now, my lords, in answer to what we say about commercial certainty, RTI, in its case at paragraphs 20 and 48, I think suggests that we are making too much of a fetish of commercial certainty. And what they seem to say is this. Certainty is only relevant if the construction of the particular contract, construed according to ICS principles, shows that the particular parties to the particular contract valued certainty, quote, above all other commercial virtues, and that it is misconceived for us to suggest any broader proposition that the law should prefer a certain answer over an uncertain answer. Now, there's no authority cited for that proposition, and in my submission, it's a novel one, and it's not correct to say that certainty is only relevant if it's relevant to the parties to a particular contract, and it's only relevant within the confines of a particular contract. The benefit of certainty is that it allows parties who are going to face the same issues in other contracts and transactions in the future to know without having to go to law what the answer is.
To know without what, sorry?
Without having to go to law, without having to litigate, my lord.
Yes.
But by the time the court has answered the question in a particular case, it may well be of no interest to the parties to that particular case to know whether the answer is certain or not. It may well be too late. The case has been going through the court or arbitration for some time. The transaction in question is over. The parties have moved on. The fact that the answer is certain may well be of no benefit to them in the slightest. The purpose of certainty, the role of certainty in commercial contracts is to lay down clear guidance for other contracts.
Yes, that depends on your submission that this is a standard or relatively standard force majeure clause and a relatively standard reasonable endeavours.
My lord, it does, and I stand by that submission. That the clause I submit is whatever one wants to call it. It's unremarkable, it's unexceptional. Yes. And the implication of reasonable endeavours provisos where they're not expressed is standard.
Yes, and if you're right about that, then the significance of certainty increases.
Indeed, my lord, yes, I accept that. Yeah. Finally, to close on this, we have quoted, and I'll just read out part of it, Professor Peel's commentary in the Lloyd's Maritime and Commercial Law Quarterly on the Court of Appeal decision in this case. It's in the authorities at page 1430. And he says this: at no point did Lord Justice Males really address Mr. Justice Jacobs' concern that if the party affected by the force majeure can be required not to insist on its strict commercial rights in an attempt to overcome it, some uncertainty has been introduced which is best avoided in commercial transactions. And we submit that that is a powerful point.
That's at 1435, I think.
that quote at 1435, my Lord, yes, and the article begins at 1430.
Yes.
And my Lord, the third, and since I dealt with the fourth one, the last point of principle, is the Gilbert Ash point. It's a truism that English law attaches importance to contractual rights. And against that background, I do submit it would be surprising if a reasonable endeavours proviso extended to requiring variation to those rights or a non-contractual performance which does not comply with contractual rights. For one thing, force majeure and excessive perils clauses are defensive in nature. They relieve the parties from liability or from the requirements to perform when there is an impediment by extraneous events. They're essentially passive. They give you an excuse. It doesn't really fit with that passive defensive nature to propose that they can have an active role in requiring a party to vary the performance or vary the contract and in effect generate a revised bargain. Secondly, it's natural to expect contracting parties to attach at least as much importance to their contractual rights as the common law does. And parties can be expected to guard their contractual rights and be slow to relinquish them. And that makes it natural to expect that if they do intend a particular reasonable endeavours proviso to extend to variation or non-contractual performance, then they will say so expressly. And that proposition just reflects the Gilbert Ash principle. We cited some material about Gilbert Ash in paragraph 91 of our case, but I suspect it's all pretty familiar, so I won't take your lordships to it. I just make the following points. Gilbert Ash it's a principle of construction. That's how Chitty describes it. Also, Lord Justice Lewison in his book describes it. It doesn't purport to state a substantive rule of law that parties can never give up rights. We don't propose a substantive rule of law that it's impossible for a reasonable endeavours proviso ever to extend to variation or non-contractual performance. We just propose a proposition such akin to Gilbert Ash that parties shouldn't be taken to have done that unless they've done so expressly. Second point is that the Gilbert Ash principle is, in many ways, it's a statement of the obvious, or as it's been more tactfully put in a couple of Court of Appeal cases, such as Seadrill and Gazprom, it's a principle of common sense. Common sense suggests that parties will not hurry to give up their rights, and you'd expect them to say so if that's what they intend. Third point, it's been a theme of the development of principles of contractual construction really since the ICS case, that the principles aim to generally reflect common sense in the sense of aligning to how reasonable people understand documents and utterances in everyday life. And that emphasis on common sense no doubt explains why the Gilbert Ash principle has been achieving increased prominence since ICS, as most clearly stated recently by Lord Leggett in the Triple Points and PTT case, paragraph 109 and following of the judgments, page 1106 of the authorities bundle. And Lord Leggett makes the point that the Gilbert Ash principle is subsuming some of the old, more formalistic rules, such as Canada steamship. These are really now being seen as aspects of a broader common sense principle that you don't expect parties to give up rights unless they've made their intention clear.
You got a page reference for that?
Well, my Lord, I've got 1106. That may be the
1146.
Yes, that's where it begins at 1146. I'm grateful, my Lord. Paragraph 109 and following. Now, Lord Justice Mayles dealt with Gilbert Ash very, very briefly, indeed. He said there was no need to discuss it. And the reason he said there was no need to discuss it was that it begs the question. He mentions Gilbert Ash at paragraph 54 of his judgment. Now that is, with respect, it's so compressed that it's quite difficult to tease out what Lord Justice Mayles meant. He may have meant, and this is perhaps the most probable explanation, that you have to construe a contract as a whole. And so the payment provisions have to be construed in the light of clause 36.3d in order to determine the scope of MUR's payment rights. In other words, it would be wrong to start with the proposition that the payment clauses gave MUR a right to payment in dollars and then say clause 36.3d should not be construed as derogating from that right. You should take the payment clauses and clause 36.3d together to work out exactly what the nature of the right is. And if you do it that way, then you come to the conclusion that MUR only ever had a qualified right to payment in dollars in the first place. That is the sense of the thinking, I suspect. And certainly that is what RTI says in its case at paragraph 94. When you read the contract as a whole, and when you take clause 36.3d into account, MUR only ever had a qualified right. It was qualified in the sense that it may have to be surrendered in the exercise of reasonable endeavours under 36.3d. But the problem with that in my submission is if you take the logic behind that approach, when you have to construe the contract as a whole, then you ultimately will come to the conclusion that the Gilbert Ash principle doesn't apply when you're dealing with contractual rights. And again, RTI embrace that. They say that that is indeed the position. They say that Gilbert Ash is concerned with rights that arise at common law. You can't extend it to rights which arise under a contract, and that if you did, you would destroy what they call Gilbert Ash's unique character. And they say when you're dealing with contractual rights, and whether a contractual right has been given up or not, you don't analyse that by reference to Gilbert Ash. You answer that by reference to, quote-unquote, general principles of contractual construction.
Well, that's how Gilbert Ash started, isn't it?
Gilbert Ash started in the context of whether a contract took away a common law right of set-off. Yeah. Yes, that was the issue in Gilbert Ash. Now, my Lord, 2 points about that proposition, that it doesn't apply to contractual rights because contractual rights have to be determined by general principle of construction. First is, the Gilbert Ash principle is a general principle of construction. That's how it's assessed by Chitty and by Lord Justice Lewison. It's not a substantive rule of law. It's a principle to guide the interpretation of contracts. But the more fundamental point is that if you adopt the logic of RTI's case, then you end up completely destroying the Gilbert Ash principle. Because you can equally say, when you're looking at rights at common law, well, the question is, what right do you have in the light of the contract? And so it's wrong in principle to start from an a priori assumption that you have a right, and then to analyse separately whether the contract derogates from it. You've got to look at the whole picture. You take the common law right together with the contractual right, and you work out what the answer is when you've looked at the two together. You don't make an a priori starting point. That would be the logic. But that's
well,
exactly...
I'm not sure that would be the logic, would it? I mean, in a sense, you've got rights that exist irrespective of a contract, and the argument being put is, well, they are, by definition, separate from the contract. And then you've got the contract.
You do, my lord.
So construe the contract as a whole, you're still left with the rights outside the contract as a matter of logic.
Well, you've got the rights unless the contract takes them away, my lord. So the logical approach would be to say, well, you've got to look at it, you've got to look at the position after the contract has been concluded. Because that's what you're ultimately concerned with. What's the upshot? What's the outcome when you've concluded the contract? And so, in my submission, the logic is exactly the same. It would, if you push the logic, you would come to the conclusion that it's wrong even with common law rights to start with your lordship's a priori assumption. Because you're not concerned with the world before the contract came along. The parties are inhabiting the world in which the contract has come along. And the question is, well,
should I put it this way? It's easier to make that distinction, if one wished to make it, in respect of common law rights outside the contract than within the contract.
My lord, that one can see, because there's a separation between the common law and the contract. But your lordship may have identified the point is if you wish to make it. And why would you wish to make the distinction in one context and not another? If it's a common sense principle, then the common sense proposition applies just as much in relation to contractual rights as it does in relation to common law rights. If you can see from one part of a contract that it has given a party a right, then the common sense point applies just as strongly that having acquired that right under one clause of the contract, you don't expect the party readily to give it up under a separate clause. And the Gilbert-Ash principle is equally at home, in my submission, when you're dealing with contract rights or with common law rights. Now, Lord Burroughs may say, well, it's not quite as equally at home, but I would submit it is, in principle, it's applicable. The common sense driver behind it applies. And it's true, as my Lord Hampden says, it's expressed by reference to common law rights in Gilbert-Ash, but that's because of the context. The context in Gilbert-Ash was, does a clause in a REBA form detract from common law rights as set off? Now, that being the context, it's undoubtedly the case that Lord Diplock did refer to rights at common law, but it's reading too much into it in my submission to extract from that a conscious decision not to extend the proposition to rights arising under a contract. And put the case, for example, suppose the parties conclude contract number one, and on the face of it, it clearly, categorically gives one of the parties a particular right. And then sometime later, they come along and they enter into a separate contract number two. And it's suggested that contract number two contains something which derogates from the rights under contract number one. Now, I would submit the court would be unlikely to hesitate to apply a Gilbert-Ash common sense principle in that context. Or if the parties enter into contract number one and then they come along later and they enter into an amendment, and it's suggested, well, the amendment has taken away something that's in contract number one. Now, we've cited in our case at paragraph 190, paragraph 103, forgive me, Mr. Justice Tier in the Ocean Victory saying that Gilbert-Ash must be capable of application to contract rights. Only first instance, of course, but I cite it because the judge said so, and because I submit it neatly expresses the correct conclusion. And because Lord Justice Lewison endorses it at paragraph 1233, which is page 1503 of the bundle. 1503, my lord.
Okay.
We've also referred in our case, the same paragraph, I think 86, to a short passage in Lord Gough's speech in Stocznia, Gdańskia and Latvian. The case is at 1054. The particular passage is at 584 of the judgment, but I'm not sure where that is in the bundle.
I'm sorry, could you just give me the reference to the Lewis
Yes, my lord.
in relation to Mr. Justice Tier?
It's paragraph 12.33.
It's at 1508.
Thank you, 1508. Yes, I see why I went wrong.
And there's a footnote reference to Mr. Justice Tier's first instance decision in the Ocean Victory.
Thank you.
Now, the Stocznia-Gdanska was a shipbuilding case. And the question, in brief, was whether, when a party had exercised a termination right under one clause of the contract, they were still entitled to recover an instalment of the price which had already accrued under another clause of the contract. And the argument which was put was, no, the termination clause is an exclusive code, and you lose your right to recover the payment which had accrued. Your only remedy is under the termination right. And in saying that was wrong, Lord Gough did refer to Gilbert Ash. And it's true that there's no express discussion of is Gilbert Ash capable of applying to contract rights, but in my submission the significance is that Lord Gough took it as fairly self-evident, or assumed that yes it did, and in my submission he was correct. What RTI say at footnote 12 is that, the right in Stocznia and Gdanska was a right to bring an action in debt, to sue for a debt, and that's a common law right. So that's another case about common law rights. But the point is that the debt only arose because the price had become payable under another clause of the same contract. It hadn't arisen as a matter of common law outside the contract, it arose under the contract. And so the question very much was, in that case, did the termination clause detract from the price payment clause? So it was a question of one contractual right against another.
What's the
Lord Gough cited.
What's Lord Gough reference again?
It's page 584 of the report, my lord, 1064 of the authorities bundle. 1064 to 1065. Apart from anything else, I submit that trying to draw a firm distinction between contractual rights and common law rights and applying Gilbert Ash is likely to lead to unclear and unsatisfactory results. And we've cited in our case at paragraph 86 Lord Diplock's famous familiar analysis of primary and secondary rights, primary and secondary obligations. The secondary obligation to pay damages arises at common law. It's a common law remedy for breach of contract. But in photo production and securicor, Lord Diplock says, nevertheless, it arises under the contract. Common law and contractual rights intertwine. It's hardly surprising, given that the common law gave birth to English law of contract. In a sense, you can't make a complete separation between the two. But take the Ocean Victory case itself. The Ocean Victory, the question was whether the insurance regime was a complete code which prevented the owners from bringing a claim under a safety warranty. It was an express safety warranty, it was a term of the contract. But if there had not been an express safety warranty, then the common law will imply a safety warranty in a demise charter or a time charter. Now, does that mean that Gilbert Ash is relevant if you are dealing with an implied safety warranty, but not if you're dealing with an express safety warranty? I submit that's not really a very satisfactory or explicable proposition to make. The triple point technology case is another example. That was an action for breach of an express contractual duty to take reasonable care. If there had not been an express duty, it would have been implied under the Supply of Goods and Services Act, or just at common law. Again, does that mean that if you are concerned with an implied obligation to take reasonable care, Gilbert Ash is potentially in play, but if you're dealing with an express obligation, it isn't, because that's a contractual right. It's not possible I would submit, to see any very clear reason why that should be so. So no reason in my submission why Gilbert Ash should not apply to contractual rights. And if it does apply to contractual rights, then it reinforces our proposition that an RE proviso does not extend to variation or non-contractual performance unless it says so. Now, Lords, there's another potential reading of Lord Justice Bales's beg the question comment, which is that you may have been suggesting, well, you have to answer the question by applying ICS and so forth, and it's a cheat and a shortcut to apply Gilbert Ash. Now, if he was saying that, he'd be basically saying, well, you jettison Gilbert Ash, and that's probably rather a bold proposition for a Court of Appeal judge to make. So one suspects that he probably was not saying that, and therefore I won't say much about that. But if he was suggesting that in the world post-ICS one can treat Gilbert Ash as baggage, then I would submit that's contrary to the treatment in triple point. And also I'd submit that the Gilbert Ash principle does, even in the post-ICS world, fulfill a valuable function, because it does provide guidance in the approach to construction of contracts, and in that sense it too helps to promote certainty. But I won't develop that aspect any further. We have dealt with it in the case. I will move on to one final point of principle. For all of those reasons, I submit that Lord Justice Males was wrong to treat the issue as being a narrow one about the meaning of the verb overcome. But even if he was right to treat it as a narrow question about the verb overcome, I'd submit he still came to the wrong conclusion. This is a short point. We've dealt with it in paragraphs 63 to 70 of our case. And the short point we make is that payment in euros would not have affected the it, that is the underlying state of affairs or event, at all. The sanctions would still have been there. The banks would still have been nervous in the light of the sanctions. The banks would still have stopped any attempt to make a dollar payment. It would still have been impossible for RTI to make timely payment in dollars. Absolutely nothing would have changed. And in our submission, contrary to Lord Justice Males' view, it is not a natural use of the word overcome to say that an event or state of affairs has been overcome when absolutely nothing has changed. What would have been done by payment in dollars would not have been overcoming it, it would have been
by paying in euros.
Sidestepping it.
Paying in euros.
Forgive me, in euros, my lord. It would have been sidestepping, it would have been substituting something else. It would not have been overcoming.
Circumventing the problem rather than overcoming it.
Well, it would not even, my lord, have circumvented it, I would suggest, because it would still have been there. That's the point. Nothing would have happened to it. It would have been a cheat's way out, really, by substituting something else. So no, it wouldn't have satisfied any synonym for overcome. It would have gone around it, but overcoming it means going through it.
But it goes back to your contractual performance point, doesn't it?
In some way, my lords.
Yeah. Mm.
My lords, authorities. We rely upon two as supporting the principle which we cite. They don't support it expressly and in terms, but we submit that Lord Justice Arnold and Mr. Justice Jacobs were both right to say that when one looks at the thinking, they support it in substance. The first is Bullman and Fenwick. It has the advantage of being very short. There are two separate reports. In the authorities bundle at 354, there's the official reports, the Queen's Bench. There is at tab 5 a law journal report, The first instance decision by Baron Pollock is almost identical in both. There are differences of expression between the Court of Appeal and between the two reports, but not, I will submit, differences of substance. So I'm going to begin with the official law report's Queen's Bench report at page 354.
Are you actually going to take us to any differences?
I will.
Right, thank you.
But I will submit, my lord, they are differences of expression rather than substance. But I will begin with the Queen's Bench report and then come to the differences in the Law Journal report. Now, your lordships will see from the top of 355 that the Ashdean was chartered to carry coal from the Tyne to the Thames, and if you drop down into Baron Pollock's second paragraph, after loading it was to proceed to London, and there were a range of discharge locations as ordered, that is to say the charter has got to select the discharge location, 84 running hours, and an exception of any delay caused by strikes. One difference between the reports is this: you don't get told in the law report what the strikes clause is. There's an abbreviated version of it in the Law Journal. It's so abbreviated I won't ask your lordships to turn it up, I'll read it out. Sundays, act of God, and strikes of workmen at the port of loading and discharging excepted. So far as one can judge from that, there is no express reasonable endeavours proviso or reasonable control proviso or anything else. It's just an exception from lay time. Now, one sees back at 355 towards the middle of the page, the vessel was ordered to the Regent's Canal, was prevented unloading by reason of a strike. The strike would have been within the clause. And just to follow through the chronology of the events, my lords, if you go to 356, round about the middle of the page, Baron Pollock says that he asked the jury a question first, and the jury answered yes, having referenced the order that was sent from London to the Tyne before the ship sailed. So the chronology from that appears to be that the order to go to the canal was given before the vessel left the Tyne. If your lordships go back to the bottom of 355, very near the bottom, the vessel left the Tyne at 1 o'clock on the morning of the 10th of February. The strike started about noon on the 10th of February. It lasted until the 17th, and the charterers became aware of it at about 4 o'clock on the afternoon of the 10th of February. And then one also sees in the top of 356 of the authorities bundle that after a great many efforts, the vessel was ordered to shift to Beckton, got there on the 18th and discharged by the 19th. But by the time it got to Beckton, the strike had already ended on the 17th. So one sees from that chronology that when the discharge port of the canal was nominated before the vessel left the Tyne, there wasn't any strike. And there's also a comment by Baron Pollock at page 357 of the second main paragraph that the strike was sudden and unexpected. So it looks as though that when the order was given, there wasn't a strike, and there wasn't a strike in prospect.
The discharge port is where?
Regent's Canal.
Is that the port, or is London the port, and these are...
One might treat it as being a port charter, but I'm not certain that whether it was a port or a berth charter played any part in the analysis or was relevant. because it did get to the canal. It got to London and it got to the canal, so whether it was a port or a berth, it got there, but having got into the berth, it was unable to discharge, and that gave rise to the demurrage dispute. Well, those are the facts, and that might be a good point to stop before coming to see what the argument and the issues were in the case.
Indeed, thank you, Steve. The court will now adjourn.